Welcome to another episode of A Fresh Perspective with Jeff Charles, with your boy, your favorite conservatarian contrarian, Jeff Charles, where we prefer truth over narrative and principles over personalities. And I've got another fire conversation for you today. We're going to talk about the Supreme Court a little bit. We've got some cases coming up that are going to be important, so I think you guys will find this very educational. But before we get into all that, we got to remember to like this video, share this video, and if you haven't already subscribed, hit that notification bell. That way you'll be notified whenever I upload a new interview. Also, remember that LibertyNation.com is a proud sponsor of A Fresh Perspective with Jeff Charles. Check out LibertyNation.com for all of your conservatarian news, original articles and analysis, videos, podcasts, Liberty Nation Radio, and their signature TV program, The Conservative Five, all on LibertyNation.com, where truth is making a comeback. Now, for this episode, we're just going to go right in. I have got my colleague from LibertyNation.com, and my favorite attorney, it's Mr. Scott Cosenza. What's going on, brother?
Jeff, I thought I was here to live snark the Amber Heard Johnny Depp trial. We're going to talk about the Supreme Court instead?
Yeah, I only told you that to get you here under false pretenses.
I see.
I know you get tired of talking about this stuff. This is important. We could talk about Johnny Depp and others.
Trial of the century.
Yeah, really. Yeah, definitely. But yeah, I mean, there's a lot that's going on with the Supreme Court, and whenever
it's got the potential to be a very big year this year. We'll see how things shake out, but the potential is there. I always like to say, as sort of a favorite line, Jeff, and this works for people who are progressives or libertarians or conservatarians or any conservative, any political stripe. If you expect the Supreme Court to disappoint you, then it's very likely your expectations will be met by the court. So.
Yes, exactly. But we've got 3 cases coming up over the next couple of weeks here. And with these types of things, I always have questions, but I mean, and you're the guy that I go to ask these questions because I'm not a lawyer. But so we've got cases dealing with the Migrant Protection Protocols, which is the Remain in Mexico policy. We've got one dealing with Miranda Rights coming up, and another one that involves prayer in school athletics. But we'll start with the immigration one first. So just to give a little bit of background before we go into this for the audience, the Biden administration has been trying to get rid of the Remain in Mexico policy, which is also known as the Migrant Protection Protocols. It was created under Trump, and basically what it does is it ends the catch and release policy that we used to have, where we used to, if people wanted to have their cases adjudicated when they come to the southern border, we would let them into the country to await to show for the court date. Same thing applied also to people who came here illegally. But now under this policy, they have to stay in Mexico and wait for their cases to be adjudicated. And if they get approved, then they can come in. And if not, then they have to go back to their home country. But this ends the situation where people don't show up for the court dates and they just stay here indefinitely, even though they're not really supposed to be here. So Biden has tried twice to end this policy, but it's always been stopped in the courts through lawsuits. And now it is at the Supreme Court level. So here's my question about this, Scott. I always believe that the executive branch basically had the power to impose policies or rescind policies as it saw fit, as long as it was backed up by legislation. Like, it can't go beyond what Congress has allowed. How does the judicial branch have the power to tell Biden that he can't get rid of a policy?
Okay, so the reason why that the court was able to do that or did do that is they said that the administration broke the law when they changed the law back. So there's something called the Administrative Procedures Act, and it governs how, you can't just change a regulation on a dime. If the law says that you have to, for instance, give a 90-day review and comment period or something like that, even though nobody who actually receives those reviews and comments is even going to read a single one of them, right? If that's what the law says, then you have to obey the law when you reverse that ruling. And that's basically what the court said with this migrant policy. They didn't say that the Biden administration couldn't reverse the policy. They just said that the way that they did it was impermissible under our current law, and they had to reverse it back. And in fact, I took a quick look at the lower court ruling before we started recording. And one thing that I noticed was that judge said that not only could they had to wait until they followed their own procedures with respect to changing the rule, they also had to do so only after, or rather they could only change the rule after they had actually installed a sufficient infrastructure in the United States to contain these people once they got here. So it's not just about the paperwork, at least at the district court level.
Okay, so if I'm hearing you correctly, it sounds like the original policy, the Migrant Protection Protocols, basically said it couldn't be rescinded unless there were certain steps that were supposed to be followed.
Well, it's any federal law or any federal or any item in the Code of Federal Regulations, right? It's not this particular law that is subject to these things. We just saw with this is what the CDC Mask Ruling was partially based on, Jeff. We saw this week. They said that the CDC didn't follow its own sort of rulemaking requirements, basically. That's one of the reasons why it was held to be illegal, an illegal grant of rulemaking, basically. So any law that is subject to the whim of executive change, right? This is not a congressional law that needs to be changed by Congress. This is an executive level rulemaking. Well, there are rules for the rules, and if the rulemakers don't follow them, that's when the courts can come in and say, well, you didn't follow your own rule, and so no go.
I see. Okay, now that makes a lot more sense. So, I mean, I guess that kind of answers the next question I'm going to ask. I mean, if the Supreme Court does rule against rescinding the Migrant Protection Protocols, what other avenues could the Biden administration pursue? But it sounds like all they would have to do is just follow the rules.
They have to jump through the hoops. That's exactly right. So it might take them, they might have to wait. I don't know. I haven't looked at the dates on this, but maybe it's an election day issue. I don't know. They might have to send those ballots south of the border to get them filled out.
That's gross. And and it's interesting that also applies to the mask mandate too, because I saw that and I didn't really delve into why they ruled against it, but everybody's saying, oh, she's unqualified, and the judge that made that ruling. But if the CDC didn't follow its own rules, then I mean, that just sounds like more politics.
Well, whether she is or she isn't, she's then impeach her if that's what you think. She, by the way, this is a woman who her name, I haven't committed it to memory yet. But in any case, she was rated unqualified by the ABA because they have a strict,
I was going to ask about that,
length of, okay, yeah. So she was, just for a bit of background for everybody who's listening and watching. This woman is a Donald Trump appointee to the federal bench. She's a district court judge in Florida, and she was the youngest appointee to a lifetime appointment. She's, I think, 33. And the ABA, in her confirmation kind of hearing, said that she was not qualified. Now, the ABA has historically been captured by progressives, leftists, Democrats at one point or another, and they often give unqualified ratings based on politics. Now, here, that may not be the case. And what I mean by that is they say that she just didn't have the years put in because she had only been, I think, practicing for 8 years when she was put up for a judge, and not, I think 12 is what they prefer, something like that.
Okay.
But in any case, there's no debate about whether this is a very smart person. Now, feel free for anybody to disagree that she should be placed on the bench based on any number of things, but not because of she kind of lacks the horsepower to do the work. She was Clarence Thomas's law clerk, and she was a law clerk to two other judges on our nation's appeals courts. And when I tell you that those are hard jobs to get, Jeff Charles, they are hard jobs to get. I certainly would have loved in my younger attorney years, even now, to be a clerk on United States Court of Appeals. It's a plum assignment, and only exceeded by the Supreme Court clerkship, by the way. So she's a smart cookie, but she's a kind of political type that they, love to hate. She didn't go to Ivy League school. She went to like a Christian college in Florida, and then a not particularly well-known law school, I think. And she also did something, and this is one of those things where, like, I'm curious about reading more about it. I'm trying to report some more about it,
okay.
Which is that she kind of rushed through this decision after the CDC said they would sort of wait and see for 2 weeks on whether or not to keep the masking up. There was a hearing scheduled, and she went ahead with this ruling before that hearing even took place. So there's cause for some gripe, concern, issue, whatever you will, from the left, but the idea that she's just some like some Trump's niece or something that he just like put on a federal court for without qualification is that's a bunk argument.
Yeah. So okay. So here. So it sounds like, I mean, and you can maybe answer this question: did the Bar Association give any other reason other than the fact that she hadn't been serving for long enough for those 12 years that you mentioned?
Also, that she had not conducted trials in the course of that time. She wasn't a trial lawyer. She did other legal work. She had 2 trials, I think they said, and both were at the outset of her legal career. Now, I would prefer it if federal district court judges, especially because these are judges who actually conduct trials, had trial experience. It's a reasonable, it's certainly a reasonable objection. I would have to say that, it would be interesting to take a look at and see when esteemed, favorited leftist and progressive legal scholars who spent time at like the U.S. Sentencing Commission and other areas, if when they're nominated for district court judgeships, is the ABA similarly interested in how many trials they've undertaken? Usually they're not, in my experience. Usually that's not as important. But if you apply that across the board, it does make sense that you'd want somebody who is familiar with the ebb and flow. And, trial is sort of like, there's keeping aside all the political implications of a trial. And, most trials are not the Kyle Rittenhouse trial in terms of the politics involved. Most of them are about some insurance matter or something like that. There really is an important, like, let's keep the trains running on time sort of aspect of judging that you'd want. You want your judges to be good judges, right? And a good judge, regardless of their politics, has to kind of keep up a courtroom. So
yeah,
it's somewhat of a reasonable objection, but again, you don't seem to see it applied to the darlings of leftist legal theories.
Yeah, and that was my whole problem. That even and I'm not even familiar with this stuff, but once if somebody on Twitter was like, "Oh, well, the Bar Association said that she's not qualified," I'm like, "Yeah, how much you want to bet that they're politically biased and that this has nothing to do with qualifications, that it's more political?"
Yeah, well,
you confirmed what I thought.
It's one of those things where you have a standard that, like, when your people want them in, you kind of give exceptions to the standard, right? But everybody else is held strictly to it. That's what it seems to me. The Bar Association the American Bar Association is a captured group. Let's just make that clear. It is not a group where people who are conservative or libertarian are welcome with open arms to be as politically open as those on the left. It's just like so many other big groups that if leftist politics, you're a hero, and then if you're a right winger, well, if they let you exist at all, it's in some ghetto corner, then rather than right out in the open.
Right, exactly. So I want to move on to the next case. And this one was really interesting to me because I hadn't heard of it before I read this article on The Hill about these cases. And it involves Miranda Rights. And so I'm just going to give a little bit of background for the audience. But this is a case where a man named Terrence Tekow, hopefully I'm pronouncing that name right, he's a hospital worker in Los Angeles, and he was accused of sexually assaulting a patient. And during the course of the investigation, Los Angeles County Deputy Sheriff Carlos Vega brought Terrence Tekow, the suspect, to a private room to discuss the case, but he didn't read him his Miranda rights. And so obviously, with the Miranda rights are, the right to remain silent, blah, 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 blah. They include a notice of the right against self-incrimination, that kind of thing. And
don't blah, blah, blah the Miranda rights, Jeff. Come on.
I only do that because I don't have them memorized. Wait, actually, let's see if I can do it. Okay, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford one will be provided for you. I can't remember the rest.
You've grown up with a television in your household. That's all that says to you.
I was just about to say that. That's what I remember from those TV shows and Law and Order.
The Miranda rights, yeah.
So, but was that right then?
Yes, you're right. And so the reason this case is a bit different. Most Miranda cases involve criminal law exclusively. This case is about the civil law. So what this case and I won't even try to manage the man's name, but what the person who was interrogated said is that he was interrogated without his Miranda rights being read, and that he wrote a confession at the conclusion of that interview. By the way, now just to be fair, there are two stories about what happened in that room. It was an MRI room, I think, in the hospital that wasn't being used. And according to the plaintiff who's suing the sheriffs and Mr. Vega, that Vega stood at the door, put his hand on his gun, and intimidated the man into confessing. Basically, sweated him out and told him that he was either going to physically harm him or have him deported. I forget where he's an immigrant from. And he also used a racial epithet, by the way. Jungle N-word is what he's accused of calling the man, and some other things. So that's what the person says. Hey, these were the circumstances under which I wrote that confession. Now the Vega says, oh no, we came in to the room. He was contrite. He wanted to express his remorse for what he had done, and it was a voluntary confession. Now, if you read both statements, I think the truth is probably somewhere in the middle, because both of them seem a bit hyperbolic in terms of what the other person was doing. So, which would be no surprise to anybody who's ever, been involved in a court case, is that people shade their truth or perceive their, so I just seem to doubt that both things happened exactly that way. But in any case, that's what's been alleged. Now, at his criminal trial, by the way, he was found not guilty of this assault. So the confession didn't help the state enough. I can't even imagine what would happen without the confession. But at his criminal trial, that confession was introduced into evidence above his objection. So he said, his attorney said, they shouldn't allow this confession in because without the Miranda warning present, it's not admissible under the Supreme Court precedent. Well, the court didn't agree that it was a confession that should have been covered by Miranda. And, we're going to have to talk just a little bit, peel the onion a little bit deeper into how Miranda works to kind of understand all this. Mm-hmm. But we'll get to that in just one moment. And so,
okay.
So what this case is about, it's a civil case. It's sort of like, police can't arrest you without a justifiable reason. If they pull you over and they say, I don't like your color shirt, and I arrest you, you can sue them in court. It's a 1983 action is what it's called. It's a violation of a deprivation of your civil rights. Okay. These are one of the laws that was passed after slavery to kind of protect people from police who would violate their rights. So the question, but it's a civil suit. It's not about crime. It's not about years in prison. It's about getting money damages from the government for how they treated you. Right. And so the question is, can this guy get money damages because he wasn't read his Miranda rights? That's what the case is about now. It's not about whether or not he's guilty or innocent of a crime.
Yes.
And the Supreme Court's going to decide this. And right now there's a split in the circuits. I forget exactly what the split is, but there are 11 judicial circuits in the DC Circuit Court of Appeals. These are our federal courts are divided into many district courts, and then above that are the courts of appeals, and then the Supreme Court above that. So like almost half and half split right now in the circuits, whether or not you can recover money damages if this happens to you. All right, now let's get into the nitty gritty about why it may or may not have been, covered under Miranda. So here's what Miranda says. The basics of Miranda are that if you are in a custodial interrogation, that's when you have the right that's when the requirement attaches that police read you your the Miranda warnings, right? That you have the right to remain silent, that anything you say can and will be used against you, and that you have a right to an attorney to represent you before you're being questioned. And if you can't afford an attorney, one will be provided by the court. Those are your Miranda warnings, and they're required when you're in custody and being interrogated.
Well, so when you get arrested, basically.
No, not arrested is different than in custody. And so that's important to get into. And that's why I talked about the room where the man was questioned, because it's basically, do you have a sense that would a person in similar circumstances reasonably believe they were free to leave? That's by and large what we're talking about here, Jeff. So it doesn't require cuffs or anything like that. But if it happened like the plaintiff says, and the cop is standing in front of the door with his gun on him, and he's menacing and yelling and whatever. Well, that no reasonable person, you might imagine, would think they were free to go at that point. So that then is an in custody. I mean, certainly if you're in cuffs in the back of a squad car or in a jail cell, you're in custody. That's not, nobody's debating that. Yeah. This is where the gray area comes in on something like this, where, they're in a room in a hospital. Well, it's debatable. Would a reasonable person feel like they were free to go? I think that if we believe the officer's account, well, then perhaps no. And if we believe the plaintiff's account, then perhaps yes.
So, okay. So because to me, it's a layperson. As a layperson, it seems like a slam dunk, because I know you're supposed to read them their rights when I was believing when you arrest them, but even if you are detaining them or they're in your custody, but so the key words you want to focus on are custodial interrogation. That's what the law requires. It's like, because if you think about it, a cop's called to a scene, or even, here's a gunshot down the street, runs a block and sees somebody standing outside. He says, what happened? If they're the murderer and they say, I murdered that guy, well, the cop didn't read them their rights, right? They just asked what happened. You can imagine that would lead to, if that was required, it would lead to some preposterous results, right? We can't have police officers, without knowing what's going on, be required to read Miranda rights, just everybody they encounter. So that's why there's this structure to the rule. It has to be a custodial interrogation. So with the courts that ruled in favor of the officer who didn't read the rights, why would they rule in favor of Vega when he didn't read him his rights? What reasons would they give for that? The reason is
it didn't meet the standard to require the reading of that rights, which was the courts then. The requirement is that it was a custodial interrogation, and I assume they think that they were ruling that a reasonable person wouldn't believe they were in custody at that point. You have part of these things too when you read about them at the appellate level. You're not at the trial court level where the persons are in front of you telling their story. And it's one of the reasons why appellate courts give deference to trial courts, because they're the ones that actually hear Mr. Vega on the stand testifying about how it went down,
right?
And hear the plaintiff testifying out, and they're the ones who are making these judgments about whether or not it would come in or not. Now, I'm not saying that doesn't mean it's beyond an appeal. It is, in fact, within an appeal right now, right? But it's just they got to make a determination, and for whatever reason, that's the determination that they made.
I see. Okay. So that kind of, you kind of answered my next question again, because I was going to ask, is there like a time period after somebody is in that custodial situation that their rights are supposed to be read? Is it supposed to be like right after they get them in that room, or is it after they maybe suspect, or is that more of just a gray area? So
here's the other thing that you have to consider. What the Miranda rule provides is it's not like if some cop, the Miranda rule says that evidence collected in violation of the rule cannot be used against you. So, Jeff, it doesn't matter if you get arrested on a Tuesday and for whatever reason you're still in jail on a Friday. As long as they haven't interrogated you, in the intervening time, they can come into your cell on a Friday and Mirandize you and then question you about an incident. And you can't say, well, I wasn't Mirandized for a couple of days while I was in custody. Well, you weren't interrogated then. It's only about the interrogation. And if it's violated, the purpose of it is to then forbid that evidence, forbid its introduction in other proceedings.
Okay, now that makes perfect sense. So yeah, that's good. I'm glad that we had this case, because there was a lot that I didn't understand about how Miranda rights work. Yeah. And that makes a lot of sense.
Well, while we're in the details, I'll tell you what fascinates me about the case. There are a number of justices on the Supreme Court who presume, I don't believe that Miranda is good constitutional law. And what I mean by that is the idea that the Constitution requires specific language to be said to arrestees, and yet it doesn't itself mention that language, meaning put it in the Constitution if you want it to be required of arrestees, right? That to me is not the best case, but also that's still that's a precedent of United States criminal law, and some might say it's a super precedent. And so within the context of that being the precedent, then how do you rule on this other case? So I think we may see a kind of interesting bedfellows when it comes to the decision that's issued in the case. because it's not about the core Miranda requirements. It's about this other civil application of Miranda. So I'm not sure what the Magic 8 Ball says things are going to do here.
Yeah, I mean, it's a tough one because I mean, without having been there and seeing the proceedings, like I don't know whether he would have reasonably felt like he could have left or not, and how this would even affect a civil case as well. I mean, because now that you put it that way, that this is usually related to whether you admit evidence into court, not necessarily in a civil case. Like I don't know, it's kind of interesting. So it'll be interesting to see how this shakes out.
Just to put a pin in it, and the Supreme Court won't rule on whether or not his interrogation was a custodial interrogation or not. That's already been ruled on. His criminal case is extinguished. So we're not even talking about that. We're just talking about what happens when cops don't read people their Miranda warnings. Can they be sued for it? Is that legal grounds for a 1983 suit? And we'll get an answer. It'll be a nationwide standard after the conclusion of these proceedings, rather than this sort of split standard that we have now. Some courts saying yes and some courts saying no.
Yeah, so this could be a landmark case, really. I mean, yeah.
It will be in this issue. It's just a relatively narrow issue. Yes.
Okay, cool. So let's move on to prayer in school. And
yes.
So this one involves, and I remember hearing about this back in the day, but there was a coach who's a Christian in Washington. I believe it was in Seattle. Yeah, it's Seattle area public school.
Bremerton School District, Bremerton, Washington. Yep.
Bremerton, yeah. And so he had a custom of kneeling on the field and doing prayer whilst, with some of the players of the football team before each game, and got into trouble, and they told him to stop because he's a public employee and this could be a constitutional violation. And the other courts, obviously they ruled against him, and now it's at the Supreme Court. But this is always very interesting to me because I never really know what to make of these, which is why I wanted to ask you about it. And so I know that the phrase separation of church and state does not appear in the Constitution. So if that's the case, why would it be problematic for a public employee to say or lead a prayer before a football game if he's not compelling people to do so?
So the Establishment Clause of the First Amendment protects from messages that indicate approval for a particular religion or religion generally from the state in school. And it's a school activity. He's a school employee. It's a school event. It's on the field. I mean, it's the idea that this is somehow private activity is, I think, a bit ridiculous. So if the messaging comes from the school, in this case, it does Coach Kennedy is the man's name. That is an endorsement of religion and an endorsement of this particular religion. I presume you said he was a Christian. I don't remember reading that, but I'll take it that he probably is. So, and schools are not allowed to do that because that promotes the idea. It certainly favors one religion over another, which is to say Christianity over Islam or Judaism or any of the thousands of other religions that are out there. And it also favors religion over non-religion. Do you think that you want to make a spot on the squad? You want to move off the bench from riding the pine to starting on the squad, or being a person who gets in after the second half is over? Well, do you think Coach Kennedy would look more favorably upon you if you engaged in this prayer? And, it seems, that's part of the reason why. And also just subjection to the messages. If you can imagine if the coach was a devout Muslim instead of a Christian, and for the Christian population of the squad, should they have to kind of feel left out about that, or pressured to express words of Muslim faith, for instance? And so that's the reason why that it's prohibited by the First Amendment, certainly according to the school district. And what the school district has said is that Coach Kennedy has a right to free speech. We're not saying he doesn't have the right to free speech.
Sure.
We're saying that what trumps his right to free speech is that the students, that we, the school district, have to protect the students from this, protect their free speech rights. They're the students. And so which party is more put upon and in the sort of more vulnerable position? Is it the coach who can presumably pray however he wants, whenever he wants, when he's not, on the field at a game that the school's provided, or the students who they can't, opt out of that part of being a student, if you will, right? I mean, I don't mean that they can quit the team if they want to, right? But then the consequence of them not being exposed to those religious messaging is to quit the team, which is not a tenable solution. Yeah.
Yeah. So, I mean, so when I look at this, I mean, and I figure that was the reason why, because it suggests an endorsement of a religion to allow him to do this. What is his defense arguing? I mean, what arguments are they giving for why he should be able to lead these prayers?
Well, he says it's within his First Amendment rights to to pray in this manner, and that the school district's actions to kind of restrict his prayer to protect the students aren't somehow trumping, or should it trump legally, his First Amendment rights. Honestly, I think his case is a loser. It doesn't seem to me like the First Amendment requires allowing this kind of prayer by a public school employee on school grounds at a school event. And Bremerton School District says that they offered the man some sort of accommodation to go pray privately. But we don't have a system where school personnel are allowed to have any religious affiliation that they want, but we don't allow them to exhibit their affiliations in demonstrative ways at the school. It's not like devout Muslim teachers who are called to prayer 5 times a day aren't allowed to stop class during the day to get their 5 in, even though it's their religious right, to pray as their religion requires. They're not allowed to do so on the public's dime when they're teachers in the public's classrooms. So it seems like the same thing would apply here.
Yeah. I mean, it seems kind of cut and dry. So it's very interesting that they're even pushing it to this level. But yeah, I guess it is what it is.
Yeah.
But yeah, I mean,
we could be surprised. Who knows what the court has in store in terms of a judgment. But
you always say that. I mean, you never know. But yeah, so these 3 cases are going to be before the Supreme Court within the next 2 weeks, and I know they've got some more going on before the end of the year. We've got that abortion one coming up. We've got that New York Rifle and Pistol Association one.
Fingers crossed, baby.
I know, and I know we'll be talking about that when those come up.
Yeah.
But just really quick before we stop, have you heard of any indications on those cases yet, like as far as abortion or also the
No, and one of the things that the Supreme Court is legendary for is not disclosing where things stand before the ruling is actually out. I think it was Scalia, maybe, who famously said to one of their clerks, if you let out some material, I will basically hound you to the ends of the earth for the rest of your legal career to tell people like they shouldn't hire you or trust you ever because of what you've done. Like, you can make any mistake you want, but never leaking, because what happens is these things go back and forth, and the clerks do have access to the arguments that are being made. So there are a few people who know what's going on, but it's a tight enough circle that it's only happened a couple times, I think, in history where it's sort of, previews have gotten leaked out.
Yeah. But they're expected to make decisions on this next month, right?
Well, the court breaks they want to get out of Dodge for their summer break. And that's when their session concludes, when they've released all their opinions. So it's sort of like you can leave anytime, but not until you're done. So they're working through it. And, a lot of these things depend on one justice may write an opinion that another justice wants to react to in their own opinion. So it depends on how much of that back and forth goes on, and, in terms of how long it actually takes to get the opinions out the door. And I'm sure that with the big ones, there's a lot more attention paid to dotting the I's and crossing the T's. Okay.
Awesome. Well, whenever they do get done and release those opinions, we got to talk about that again too, because I'm sure there's going to be a lot to cover. So, but but before we sign off, why don't you tell everybody where they can find you?
LibertyNation.com.
Awesome. And that gives me a segue to remind you to head on over to libertynation.com, a proud sponsor of A Fresh Perspective, where you can read my stuff, you can read Scott's stuff, excellent news and analysis without, all that spin and all the superficial talking points, all the nuance from a wide range of right-leaning opinions, whether you like the traditional Republican types, we've got that. If you're more of a conservatarian like myself, that's great. If you're a full-blown anarchist like Scott, no, I'm just kidding. But you
Depends on the day.
Yeah, it depends on the day, exactly. Yeah.
And let me just say this while you're plugging me. Let me get a plug in for the Uprising podcast as well. Yes. It's a podcast at libertynation.com. We chop up issues like this all the time.
And you release on Fridays of each week?
Usually, and people can head over to libertynation.com and look on the podcast tab and check it out.
Awesome. Yeah, check all of that out at libertynation.com, where truth is making a comeback. Thanks again for joining the program, Scott.
Thanks, Jeff.